Yes, Mr. Roberts, we're moving on to Appeal 2.
We are, my lord. Although I should say briefly before we start that there were some questions hanging over from this morning, including those of my lord Justice Newey in respect of, for example, how many documents were disclosed in January 2023. My instructing solicitors, Hill Dickinson, were not involved at the time, so I'm afraid they don't have that information at their fingertips. What we propose is to find the answers to those questions as quickly as possible after court today, seek to agree them with the other side, and then provide your lordships with
yes,
agreed answers.
I don't think we need an exact number, but
exactly. But I'm afraid just because they weren't involved, it's not information at their fingertips, I say. So we move on to Appeal 2.
Just to set the ground rules for Appeal 2, if you are right on Appeal 1, the judge wrongly debarred your clients from defending and wrongly struck out their defences, and so it would follow, I think, that Appeal 2 should be allowed.
That's right.
So we are therefore approaching Appeal 2 on the basis that the judge was correct, or at least not wrong, in striking out your client's defences and debarring them from defending.
That's right. I can cross off my first point because my lord's made it for me. Appeal 2 relates to the hotel site. As your lordships have seen, the plot of development land in Birmingham known as the Square consisted of the residential site and the hotel site. The residential site was sold to a developer called Cortland. The hotel site was retained, and the economic interest in the hotel site was held initially by the second defendant. The respondent Sandman, which, as my lords know, was the second claimant below, said that it had entered into a binding agreement with the second defendant, under which it would be entitled to 50% of any profits from the hotel site. Now, what happened in the event was that the economic ownership of the hotel site was, in effect, transferred from the second defendant to the fourth defendant, and the second defendant didn't make any profits on that disposal. And since Sandman hadn't entered into any profit-sharing arrangement with the fourth defendant, it was not going to receive any share of any profits that might be made from the hotel site by the fourth defendant. And Sandman's case in these proceedings was intended to resolve that problem, and that case had 4 parts. First, Sandman said that the profit-sharing agreement with the second defendant contained an implied term to the effect that the second defendant would not dispose of its economic interest in the hotel site in such a way as to defeat Sandman's right to 50% of the profits. Secondly, Sandman said that that implied term had been breached by the second defendant when the second defendant transferred its economic interest to the fourth defendant. Third, Sandman said that the other defendants were liable for the tort of procuring a breach of that implied term. And fourth, Sandman said that the other defendants were also liable for the tort of conspiracy to cause harm using unlawful means, the unlawful means being the breach of the implied term. And so in that way, the transfer from the second defendant to the fourth defendant was said to be the wrongful act which lay at the heart of the various causes of action. It was the breach of contract, which was said to have been procured, and it was the unlawful means in the conspiracy tort. Sandman's problem was that the fourth defendant has never made any profits from the hotel site. It's not clear that any profits will ever be made. That's not a consequence of the fourth defendant's economic ownership of the hotel site. The second defendant and the fourth defendant are controlled by precisely the same people. Even if the hotel site had remained in the ownership of the second defendant, there still wouldn't have been any profits. The transfer of the economic ownership of the hotel site from the second defendant to the fourth defendant might have impaired Sandman's right to receive 50% of any profits, but it didn't change the fact that there weren't any profits. 50% of nothing is nothing. And that's why the debate at the pleading stage came to focus on the counterfactual. What's the basis for saying that the second defendant would have made profits from the hotel site when the fourth defendant hasn't been able to do so. And Sandman sought to set out its case on that in paragraph 20E of the re-amended particulars of claim, which your lordships will find in the core bundle. The core bundle has the pleadings in it, and the particulars of claim, just looking for them now, re-amended is, sorry, what I'm trying to...
It's tab 12.
Tab 12, that's right. Thank you, my lord.
Which paragraph you say?
It's page 191, 20E. And the heading in the middle of the page, the second claimant's primary quantum case. And subparagraph 1 says the second claimant's primary case on quantum proceeds on the basis that but for the said breaches, and obviously, inevitably, that's a crucial part of Sandman's case. It said that if the economic ownership of the hotel site hadn't been transferred to the fourth defendant, but had instead remained with the second defendant, there would have been profit. And then as regards the hotel site in particular, the primary counterfactual case begins on page 192 in subparagraph 3 in relation to the hotel site. And there are 4 counterfactual scenarios. It's important to look at them. Number 1 is that the second defendant, or an appropriate vehicle through which profits would flow to the second defendant, would have built a hotel on the hotel site, secured a contractual operating agreement with a first-class hotel operator such as Marriott Moxie, and thereafter sold the hotel site to a third party with the benefit of the built hotel and the concluded hotel operator agreement. Alternatively, 2, the second defendant or an appropriate vehicle would have secured a contractual operating agreement with a first-class hotel operator and thereafter sold the hotel site to a third party. So that's slightly different in that they don't build the hotel, they just get the agreement with the first-class hotel operator. And then in the further alternative, 3, the second defendant or an appropriate vehicle would have sought and obtained planning permission to change the permitted use of the site from hotel use to residential use, and would have sold the hotel site to a third party on the basis the second defendant would have entered into a development agreement with that third party or its affiliate to build and or develop residential accommodation in respect to the hotel site, similar in terms and structure, while taking account of different size and values of the 2 sites to the development agreement. And then in the yet further alternative 4, the second defendant or an appropriate vehicle would have sought and obtained planning permission to change the permitted use of the site from hotel to residential, and would have built and or developed residential accommodation itself, and then would have sold the hotel site with the benefit of the built residential accommodation. So that's change of use and building the residential accommodation. And then importantly, subparagraph 5, given in particular that the sums to be received and the profits made may not be known by the time of the trial, the second defendant shall seek to adduce expert evidence in relation to the matters set out above. So Sandman was going to apply for permission to adduce expert evidence on the counterfactual case. Now, of course, we say that Sandman's various counterfactual cases were flawed because they failed to grapple with a rather obvious point. What's the basis for saying that the second defendant would have been able to achieve any of those things, given that the fourth defendant hasn't been able to achieve any of them? For example, what's the basis of saying that a first-class hotel operator such as Marriott Moxie would have been interested if the hotel site had been in the economic ownership of the second defendant instead of the fourth defendant? If, without the transfer of the hotel site to the fourth defendant, there still wouldn't have been any profits, then Sandman hasn't suffered any loss because 50% of nothing is nothing. And District Judge Phillips accepted that this was an important point. She made an order for a split trial and ordered that the counterfactual issue would form part of the first trial. Order is in the supplemental bundle. I think it's one of the first things. A second order tab 2, and it's page 8 that you need to look at. Second page of the order, paragraph 11. There is to be a split trial as follows. 11.1. At the first hearing, the court will try the claim by the first claimant against the first defendant and the following issues in the claim by the second defendant against the defendants. One is whether the defendants or any of them are liable in respect to the causes of action. And 2, Roman 2, what the appropriate counterfactual scenario for the purpose of assessing quantum is by reference to counterfactual events pleaded at paragraph 20e of the re-amended particulars of claim and such other scenarios as may be pleaded by way of defence herein. And then 11.2, if the second claimant succeeds on those issues at the first hearing, the court will direct a second hearing to assess the quantum of the second claimant's damages and give directions for any further disclosure evidence, including expert evidence as required. So, my lords, that's not an order for a liability trial followed by a quantum trial. It's more precise than that, and it's clear because it's spelt out in terms that the counterfactual issue will form part of the first trial.
But in view of a paragraph in the particulars of claim you showed us, it's curious that she did not permit expert evidence.
They didn't apply for it. It's up to, and a point I come back to, it's up to a claimant to adduce the evidence that it needs, whether factual or expert, and if expert, it's up to a claimant to apply for the necessary permission. It's not an inquisitorial system where it's for the court itself to decide how the parties ought best to present their cases.
I'm reluctant to interrupt. Just on a point of fact there, it's my understanding that the learned judge refused permission for expert evidence. So
District judge.
The district judge, I'm sorry, yes. So I wasn't there, obviously, but that's my understanding, and I wouldn't want the court to proceed from here on an erroneous basis.
Do we see that in the order?
I'll see if I can.
I'm afraid I'm not aware of anything to do with that, and I haven't seen it in the order. Or
I mean, one could logically draw a distinction. One could say, well, let's work out what would have happened. And then once we've worked out what would have happened, we get expert evidence in to work out the value of it.
Yes, precisely. And what?
But you might have needed some expert evidence even on the counterfactuals.
Well,
if for instance, there were to be expert evidence on the prospects of getting planning permission,
yes,
for instance, to change from hotel to residential, or whether a first-class hotel operator would have been interested in this location.
yes, and it's for the party making that case to apply for permission, and if it's refused, it's for that party to appeal. But it's clear from the terms of the order that, that there's no brief order for a liability trial to be followed by a quantum trial. It's much more precise than that, and it's spelt out in terms that the counterfactual issue will form part of the first trial. And as I say, that's the basis on which the case proceeded to trial. Nobody appealed. Now, of course, as we discussed at the beginning of this afternoon, the learned judge's decision, if we assume that was right on Appeal 1, had the effect of debarring the defendants from participating in the first trial, but obviously it didn't remove the need for Sandman to prove its case. And I don't think that that's going to be a controversial point, but it was put rather neatly by Mr. Justice Calver in a case called Al Saud and Gibbs that my lords will find in the authorities bundle at tab 28. I don't think we need to turn it up, unless your lordships wish to see it. It's page 437 of the authorities bundle, Roman 8. Of course, where a defendant is not permitted to participate in the trial by reason of an order debarring him from defending a claim, the claimant does not automatically win by default at the trial. The claimant must satisfy the court that he is entitled to the relief sought. In this case, it remains for the claimant to prove her claim and her entitlement to the damages sought. So the trial, as I've said, happened on the 15th of October 2024. And notwithstanding the terms of paragraph 11.1 of the order of District Judge Phillips, Sandman turned up without any evidence in support of any of the counterfactual events pleaded in paragraph 20E of the re-amended particulars of claim. And to come back to my Lord Justice New's point, Sandman didn't adduce any factual evidence on the counterfactuals, let alone any expert evidence. There was no appeal from any refusal to permit expert evidence, if indeed that's what happened, no renewed application at any stage prior to the trial, even though that had been foreshadowed in subparagraph 5 of paragraph 20E. And we say, of course, that the absence of any evidence on this point from Sandman is no surprise, because there isn't any basis for saying that all would have been milk and honey if only the economic ownership of the hotel site had remained with the second defendant instead of being transferred to the fourth defendant. Now, in those circumstances, we say the judge should have held that Sandman had failed to prove its case on this issue, and he should have dismissed Sandman's claim in respect to the hotel site, or at least held that Sandman was entitled to only nominal damages. And the first point...
They would get nominal damages if there were a breach of the implied term, loss or no loss, but the tort claims would fail if no loss.
My lord's right, yes.
And just to understand, you said that they were entitled to 50% on the judge's findings of the hotel site profits.
Of any profits, yes.
So what happened? The residential site was developed
Yes.
with no profits, or are there? Or
Well, the
are there
hotel-
might there be profit.
The residential site is developed, but that's a separate matter. This claim is confined to the hotel site, and there aren't any profits.
Yeah.
And we say the judge should have, as my Lord Justice Lewison helpfully clarifies, held that Sandman was entitled to nominal damages on the breach of contract claim and then dismissed the tort claims because damage is the gist of the tort. And the first point to make here is a very general one. My Lord Justice Lewison famously said, the trial is not a dress rehearsal, it is the first and last night of the show. And that's...
You can have an interval between acts 3 and 4.
Well, not when an order tells you what's going to be in Act 1 and you turn up without any evidence to prove your case. Then you lose. You don't get a second chance. You don't rewrite the play to change the order of the acts. And that's the case whether the defendant has been debarred from participating or not. The second point is, obviously, in contract, if you prove breach but not causation, you get nominal damages. And that is probably too well known to require any citation of authority, but we've provided some authorities. I think we can get everything we need just from the head notes very briefly. In the authorities bundle at tab 2, there's a case called Sykes. It's a decision of this court. And on the second page of the report, in the head note, held 2 between C and D, that accordingly the plaintiffs were entitled to 40 shillings nominal damages for breach of contract, but to recover substantial damages, the onus was on the plaintiff to establish that if they had been properly advised, they probably would not have entered into the underleases or entered into them on terms on which they did, and that the plaintiff had failed, on the facts, the plaintiff had failed to discharge that onus and therefore could not recover more than nominal damages. So if you fail to prove a counterfactual that you are required to prove, you get in contract, you get nominal damages. And then one more example, we can take it very briefly. Tab 3, a case called Brandeis and Goldschmidt, another decision of this report in the head note held at F, I think it is, in having adduced no evidence to show that if the copper had not been detained, it would have been processed and the proceeds applied in reduction of their overdraft, the plaintiffs had failed to establish the second head of loss claimed and accordingly were entitled to only nominal damages for the infringement of their right to possession of goods. The third point is that in contracts, if you prove breach but not causation and are entitled to nominal damages, then you get nominal damages. What you don't get is a second chance. And that's clear from Banks and Woodhall in the authorities bundle at tab 4, another decision of this court. We can jump straight to paragraph 57, page 57 of the authorities bundle, where there is some highlighting in the margins. In my judgment,
57.
57, yes, 20 internal,
Yeah.
57 in the bundle. In my judgment, this is not a case where it would be right to give the plaintiff a second chance to conduct his case. He failed in the first instance to adduce the necessary evidence to persuade the judge that the defendants were negligent or breach of statutory duty. And then this is the important bit. He failed to produce the necessary evidence upon which the judge could find that certain precautions should have been taken, and that those precautions, had they been taken, would have made a material difference to the plaintiff's condition. In my judgment, it would not be right and just to allow the plaintiff whose evidence essentially was not accepted by the judge to have another bite of the cherry. And that's another case where there's no evidence on counterfactual, so the claimant loses. But in the present case, the judge went wrong because instead of dismissing the hotel site claim or holding that Sandman was entitled only to nominal damages, he gave Sandman a second chance. And the relevant judgment for this is in the core bundle at tab 8. And to put what he said about this in context, in the earlier parts of the judgment, the judge holds that there was a binding agreement between Sandman and the second defendant, by which Sandman was entitled to 50% of any profits from the hotel site. So they succeeded on the implied term. He holds that they succeed on the agreement. He then holds the agreement contained an implied term that the second defendant wouldn't dispose of its economic interest in the hotel site to defeat Sandman's right to 50% of their profits from the hotel site. So they, as I say, they succeed on the implied term. And then he holds the second defendant has breached that implied term by the transfer to the fourth defendant. He holds that the other defendants, other than the fifth defendant, were liable for procuring that breach. And he holds that the defendants, other than the fifth defendant, had conspired to use that breach with the intention of inflicting harm on Sandman. And on that basis, he holds that Sandman is entitled to damages equal to 50% of any profits that would have been made from the hotel site by the second defendant if the economic ownership of the hotel site had never been transferred to the fourth defendant. And then he turns to the issue, the second issue.
That's at para 266, is that right?
Yes, absolutely. I was going to go to page 154. I don't know if that's the right. I was going to start it a bit later, but at the bottom of 153, you have the heading, issue 15, what is the appropriate counterfactual scenario, if any, for the purposes of assessing quantum by reference to the counterfactual events pleaded at paragraph 20E of the re-amended particulars of claim. And then over the page 268, he explains the order of District Judge Phillips. And 269, he explains paragraph 20E of the re-amended particulars of claim. And then at 155, he turns to Sandman's attempt to get around its failure to adduce any evidence on this issue. And in short, as you'll have seen, Sandman tried to argue that the defendants had somehow admitted its case on the counterfactuals. But on page 156 at 273, the judge rejects that argument, and Sandman's not appealed against that decision, so the shortcut failed. And then at 157, towards the top of the page, my lords will see the subheading, does Sandman have to prove at the liability trial which counterfactual scenario represents Sandman's loss? Now, the first point is that it was inaccurate of the judge to refer in that subheading to the liability trial. Paragraph 11.1 of the order of District Judge Phillips identified the issues for the first trial, and liability was, of course, one of them, but it wasn't the only one. The question in that subheading should have been, does Sandman have to prove at the first trial, which counterfactual scenario represents Sandman's loss? And the answer to that question is, well, obviously yes, because that's what's been ordered by paragraph 11.1 of the order of District Judge Phillips. But the judge's error in the subheading does helpfully identify where the judge started to go wrong. He's started by assuming incorrectly that the first trial is a liability-only trial, with the second trial being a quantum trial. And then he asks himself whether the counterfactual issue is a causation issue which forms part of liability, or a quantification issue which forms part of quantum, to try to work out whether it goes in the liability trial or the quantum trial. And we can see that very clearly at page 158, at the bottom of the page, paragraph 277, where the judge says, I ask counsel to refer me to any authority that would assist me in determining whether the choice of appropriate counterfactual scenario for the hotel site is, as Mr. Atkins maintains, a causation issue, or as Mr. Mallon maintains, a quantification issue. And then he says he's only referred to one authority, which is a passage from McGregor on damages. But that question that the judge has asked counsel is irrelevant, because whether it's a causation issue or a quantification issue, it forms part of the first trial, pursuant to paragraph 11.1 of the order of District Judge Phillips. The judge then says in paragraph 278 over the page, in my judgment, determining which counts in respect to the hotel site is a quantification issue and not a causation issue. Well, that's irrelevant, because whether it's a causation issue or a quantification issue, it forms part of the first trial, pursuant to paragraph 11.1 of the order of District Judge Phillips. It was not a liability trial. It was a trial of the issues directed by paragraph 11.1 of the order of District Judge Phillips. So the judge's starting assumption was wrong, and everything that follows from it was wrong. As we say in paragraph 21 of our skeleton argument for Appeal 2, it does not matter whether the counterfactual issue is one of causation or quantification. The Phillips order had ordered that it be tried at the first trial, whatever sort of issue it was. And then the judge addressed the order of District Judge Phillips.
Is the distinction between causation and quantification? In order to establish liability in tort, you need to prove a loss.
Yes.
A real loss,
yes,
not a theoretical loss.
Yes. Absolutely, and that's a point that we come on to make.
My distant memory is that there are some cases about entering judgment where causation has not been admitted, but negligence has. So you can't do it.
Yes, and then there are all the tort cases on asbestos-related injury, like pleural plaques, which reinforce that there has to be something more than a theoretical loss. There has to be something of substance which the law recognises as compensatable damage, giving rise to entitlement to substantive damages. So it's something that comes up in many contexts, and we would submit is well known. And that's a point that we go on to make. But our first point is that issue of categorisation, of whether it's causation or quantification, is actually irrelevant, because the first trial is not a pure liability trial. It's a trial of the orders directed by paragraph 11.1 of the order of District Judge Phillips. We go on to say, if that categorisation has any relevance in this debate, which we deny, then the judge got it wrong, because in terms of the tort claims, it's plainly a liability issue. Damage is the gist of the tort. Without damage being proved, you lose. So if it gets to that debate, we say that the judge went wrong, but we say that at a prior point in the reasoning, the judge went wrong, and that his decision should be overturned, because it wasn't a pure liability trial. It was a trial of the issues directed by District Judge Phillips, which the judge then deals with at page 160, at paragraph 279. And the key point that he makes in these subparagraphs is that it isn't going to be possible, in his view, to decide the counterfactual issue without expert evidence. That runs right through this. We see in A, in the last 4 lines, where he says, however, absent expert evidence Such an approach would only make sense if the correct counterfactual scenario could be identified and determined as a factual issue without the assistance of expert evidence. And then B, no expert evidence was directed for use at the first hearing. Well, it's not entirely clear whether it was refused or whether it wasn't sought, but he says it wasn't directed for use. And then he says, I asked Mr. Atkins how it would be even theoretically possible to decide on the balance of probabilities a question of fact without the assistance of expert evidence, what would have happened or will happen to the hotel site if 2020 had not been deprived of the benefit of the hotel site, given that it has not been sold. And then C, I do not consider that without the benefit of expert evidence, the court could sensibly come to any conclusion as to what would have happened to the hotel site if the scheme had not removed it from 2020. And then, I mean, even again on D, over the page, we get that again, where he says, for that reason, in my judgment, if District Judge Phillips anticipated, as it seems she did, that it was convenient and appropriate for the court to decide at the first hearing without the benefit of expert opinion, and as a question of fact, what would have happened to the hotel site, but for the scheme being entered into, with the benefit of hindsight, she was wrong to do so. And, my lords, we make 3 points on all of that. First, if the judge was right to say that it was impossible for the court to deal with the counterfactual issue in the absence of expert evidence, then he reached the wrong conclusion about the consequences. The correct conclusion in those circumstances was not that District Judge Phillips was wrong. The correct conclusion was that Sandman had come to trial without the evidence that it needed to prove its case. It had failed to prove its case, and its claim in respect to the hotel site should be dismissed, or insofar as contract was required, that it should be entitled to only nominal damages. In other words, if the judge couldn't find in favour of Sandman on the hotel site without expert evidence, then the fact that Sandman hadn't adduced expert evidence meant that the judge should have decided the issue against Sandman. But the second point is that it's actually not a point about expert evidence or only expert evidence, because Sandman hadn't adduced any evidence at all on the counterfactuals, whether factual or expert, to show what would have happened to the hotel site if the second defendant hadn't transferred economic ownership to the fourth defendant. And in those circumstances, it's even more obvious that Sandman had failed to prove its case on the counterfactual issue, which District Judge Phillips had ordered to be tried at the first trial. The third point is that it wasn't open to the judge to hold that the order of District Judge Phillips was wrong. He wasn't sitting in an appellate capacity. He didn't have any power to hold that the order of District Judge Phillips was wrong, particularly in circumstances where no one had ever appealed against the order of District Judge Phillips. So we say that the judge's reasons for disagreeing with paragraph 11.1 of the order of District Judge Phillips are not good ones, and that appeal 2 should be allowed. Now, your lordships would have
also say that in subparagraph D, District Judge Phillips didn't anticipate that it was convenient to decide the counterfactual without the benefit of expert opinion. She didn't say anything at all about it.
Well, or if my learned friend's right, she rejected an application and they didn't appeal. But either way, prior orders had been made and not appealed from, and this judge had no appellate power to overturn them on the grounds that he thought they were wrong. So his reasons weren't good ones. We say appeal 2 should be allowed. Your lordships will have seen that our skeleton argument for appeal 2 anticipates that the other side would file a respondent's notice raising different or additional reasons on which the learned judge could have relied in order to reach the same conclusion. And we say, for example, in paragraph 21 of our skeleton argument for appeal 2, that the judge didn't address his powers to vary the order of District Judge Phillips or to adjourn a hearing or the basis on which those powers could be exercised. And we explain in paragraphs 22 to 24 why those powers do not provide different or additional reasons on which the learned judge could have relied in order to reach the same conclusion. But I don't think I need to address your lordships on those points, because the other side haven't filed a respondent's notice, and they don't even say in their skeleton argument for Appeal 2 that the judge could and should have exercised powers of variation or adjournment to reach the same conclusion. To the contrary, they say in terms in paragraph 3, so paragraphs 3 and 4 of their skeleton argument for Appeal 2, that the judge did not exercise those powers and that those powers are irrelevant. Instead, what they seek to rely on in their skeleton argument for Appeal 2 is CPR 29.9, which they say justifies the judge's decision in respect of the counterfactual issue. Now, as your lordships will have seen from our supplemental skeleton argument on Appeal 2, the first point we take on CPR 29.9 is that the judge didn't rely on it, unsurprisingly, given that it wasn't mentioned to him in submissions. It didn't form any part of his reasoning. And so if the respondent wishes to rely on CPR 29.9 now, in opposition to this appeal, it has to file a respondent's notice saying that CPR 29.9 provides a different or additional reason, but it hasn't done that. And so it's not open to the respondent in this court to seek to justify the judge's decision by reference to CPR 29.9. And my lords will see that in the core bundle in our supplemental skeleton argument for Appeal 2, which my lords will find at tab 27, and it's page 454. And the relevant part of that skeleton argument, as my lords will have seen, is from paragraph 2 through to paragraph 4, where we explain that the judge didn't rely on it. If they want to rely on it, they should have filed a respondent's notice, but they have never sought to do so. Now, in case we're wrong about that, we do, of course, address CPR 29.9 to explain why it doesn't justify the judge's decision on the counterfactual issue. And we refer to the decision of Mr. Justice David Richards, as he then was, in a case called Damage Control, which my lords will find in the authorities bundle, tab 11, which is page 142. The authorities bundle. And this was a case about how a trial judge should approach a previous order. And counsel in that case had sought originally to rely on the power to vary previous orders in one of what we used to call the aeroplane rules. Rule 747 of the Insolvency Rules 1986. But that power was not available for the reasons set out by Mr. Justice David Richards in paragraph 13 of his judgment that my lords will see on page 146, where he explains why Rule 7.47 was not available. And so counsel for the appellant in that case sought to rely instead on CPR 29.9, which was set out by Mr. Justice David Richards in paragraph 14 at lines 35 and 36. Unless the trial judge otherwise directs, the trial will be conducted in accordance with any order previously made. And then Mr. Justice David Richards said there's a provision in identical terms in CPR 28.7 applicable to fast-track cases. Mr. Margolin's submission before the registrar and before me is that the words "unless the trial judge otherwise directs" confers upon the trial judge a wide and unfettered jurisdiction to depart from orders previously made in relation to the case if, in the interest of disposing of the case fairly and justly, he considers it right to do so. And then Mr. Justice David Richards explains that the registrar had rejected that submission. And then over the page, at page 147, Mr. Justice David Richards records a submission being advanced on appeal, which my lords will see starting in line 14, paragraph 16. On this appeal, Mr. Margolin, on behalf of the Secretary of State, submits the registrar erred in confining his consideration of the application to a reconsideration of the matter only if there was a change of circumstances or possibly some other exceptional circumstances which would justify him in deciding again the issue which had been decided against the Secretary of State by Registrar Derritt. It submitted that he erred in considering the proper course of the Secretary of State, rather than renewing the application, was to seek to appeal the order made by Registrar Derritt. And then he says in line 20, this raises a point of principle about the proper approach to be taken by a trial judge when asked to depart from an order previously made in the proceedings. As I've indicated, Mr. Margolin submits that the rule is expressed in very broad terms, and he submits that the purpose and effect of the rule is to confer a wide and unfettered jurisdiction on the trial judge to depart from previous orders if he considers that the just disposal of the case requires it. And then the judge begins his reasoning in paragraph 17, and at the bottom of the page, he says, starting at the end of line 2, he's talking here about the power to vary orders in CPR 3.1, open brackets, 7, close brackets. In some parts in the transcript, it looks like he's talking about 3.17, but it's 3.17. He says right at the bottom of the page that CPR 3.17 is a power to vary orders, and then at the top of the next page, at the end of line 2, he says that the power contained in 3.17, like the power in CPR 29.9, is expressed in general terms, but there are a significant number of authorities which have established that the power under 3.17 is not to be exercised in an unfettered way, but to put the matter broadly, is to be exercised only where there has been a material change of circumstances since the previous order of the court, or where the court previously acted on a materially false basis, and possibly there may be some other very exceptional circumstances in which the power may be exercised. And then Mr. Justice David Richards concludes over on 149, paragraph 22. He says, Mr. Margolin submits, in these circumstances, is forced to submit the power of the trial judge under 29.9 to consider again an application to use expert evidence is not constrained in the way that consideration of a second application made before trial would have been constrained. In my judgment, that cannot be the right approach. Of course, there may be circumstances which become apparent to the trial judge, such as the way the parties are putting their case, or indeed the way the trial judge views the issues, which may make it appropriate for him to either refuse to hear expert evidence which permission was previously given, or indeed to allow expert evidence in circumstances where permission had previously been refused. But that is in a case in which there has in substance been a material change of circumstances. The nature of the case appears differently at trial than it previously appeared. That is not the case here. And then 23, he says, in my judgment, there are good reasons of principle and practice that the power of the judge under 29.9, certainly as it applies to substantial questions such as permitting expert evidence, should be subject to the same considerations as apply to the power under 3.17. It would hardly be consonant with the policy of encouraging orderly, efficient and economic preparation of cases for trial if at the trial any party could invite the judge to revisit questions previously determined as to what expert or other evidence should be admitted without being required to show some material change in circumstances. It would leave all parties in a very unsatisfactory position if they knew that at trial they could find previous decisions which had been the matter of full argument and reasoned judgment being up for reconsideration without, as I say, a material change in circumstances. I therefore conclude Mr. Registrar Jakes was right to approach the exercise of the court's power under 29.9 in this case as being subject to those constraints. Now, as regards paragraph 23, the other side rely on the reference to substantial questions such as permitting expert evidence in line 20, and they say that a decision about which issues will form part of a trial is not a substantial question of the type contemplated by Mr. Justice David Richards. And that's wrong. A decision about which issues will form part of a trial is plainly substantial in the sense intended by Mr. Justice David Richards. It will have a bearing on everything from the scope of disclosure to witness statements and so on. And more importantly, for the reasons I've explained, it will have a bearing on who wins and who loses, because if you turn up without evidence to support your case on an issue which has been ordered to form part of the trial, then you lose. So in that sense, it's not merely substantial, it is capable of having substantive effect on the rights and obligations of the parties. Mr. Justice David Richards then referred to the notes in the White Book dealing with fast-track cases where the equivalent power to CPR 29.9 is mentioned. And then there's a quote on page 149 from the White Book between lines 35 and 46. And we can pick it up at line 40 towards the end of the line where the White Book says Rule 28.7 does enable the trial judge to otherwise direct. The trial judge is likely to do that only in non-controversial circumstances. Time is limited at a fast-track trial, and the trial judge is most unlikely to allow part of it to be used up by what is in effect an application to vary or appeal directions previously given. And then Mr. Justice David Richards says in line 49, although there is a specific reference in that passage to the particular time constraints on a fast-track trial, in my judgment, the note accurately sets out the approach of the court and applies also to the power under 29.9. And it goes on to say the statement that the proper course of a dissatisfied party is to appeal a previous order and not to wait until trial, and the restriction on the exercise of the power to depart from a previous order to an exceptional appropriate case echo both what Mr. Registrar Jake said in his judgment and the principles established in relation to CPR 317. And we say that what Mr. Justice David Richards, as he then was held about CPR 29.9, is correct and should now be endorsed by this court. CPR 29.9 isn't some sort of magic bullet for the other side. For the reasons that we gave in our skeleton argument, it's subject to the same constraints as the power in CPR 3.17, and therefore the reasons set out in our skeleton argument for saying that CPR 3.17 couldn't justify the learned judge's approach are equally applicable to CPR 29.9. There had been no material change in circumstances to justify a departure from paragraph 11 of point 1 of the order of District Judge Phillips. The other side say that there had been a material change in circumstances in that the defendants had not amended their defences in response to Sandman's counterfactual scenarios in paragraph 20E. But that's irrelevant. The judge held that the defendants hadn't admitted Sandman's allegations on the counterfactuals. There's been no appeal by Sandman against that decision. It remained necessary at the time of the trial before the judge, just as it had been at the time of the order of District Judge Phillips, for Sandman to prove its case on the counterfactual issue. My lords can see what the other side say about this in the core bundle at it's page 449, which I think I'm right in saying is going to be behind tab 26. And this is paragraph 23 of the skeleton argument, where they say that end of line 2, beginning of line 3, there was a material change in circumstances. And the proceedings have developed considerably since the district judge decided in February 2023 the order in which issues were to be trialled. These developments included the fact the appellants did not challenge or advance any positive case on counterfactuals. Well, the judge has held that that's irrelevant. They haven't admitted it. It remains necessary for the respondent to prove its case. There was therefore no engagement on the counterfactual scenarios by the appellants. Well, irrelevant. It was necessary for the respondent to prove its case. And then they say, by the time of the trial, it was apparent the division of issues between first and second hearings, the split trial ordered in February 2023, did not work. Well, there's no basis for saying that. It remains entirely conceptually workable. Makes sense to say the first trial will deal with liability and the counterfactuals. And then the factors justified a variation of the 22nd February 2023 order. And to the extent necessary, demonstrated a change in circumstances. So as my lords can see, what they say on material change in circumstances is really so thin as to be non-existent. There hadn't been any material change in circumstances of the type that would justify the variation of a previous order. And finally, in case your lordships were to decline to follow the approach of Mr. Justice David Richards, I should say that whatever be the basis on which the discretion in CPR 29.9 is to be exercised, it cannot be right for a trial judge to exercise the discretion to vary a previous order so as to prevent one side or the other from losing. It's obviously fundamentally wrong to say, well, I'm going to vary the previous order because if I don't, then the claimants will lose. And I say that to address the submission in paragraph 31 of the other side's skeleton argument, the skeleton that we're looking at. It's on page 452, where they say in paragraph 31 that if the decision to adjourn the counterfactual was appropriately described as a variation or an adjournment, it was obviously in the interest of justice that such an order be made, given that the 22nd of February order made proof of the relevant counterfactual scenario impossible, and the judge decided that the respondent was entitled to judgment for damages on the basis upon which those damages were to be assessed. Now, the assertion that the 22nd of February order, i.e. the order of District Judge Phillips, made proof of the relevant counterfactual scenario impossible is obviously wrong. It doesn't contain anything in it that prevents Sandman from adducing factual evidence. There's not even anything in it that refuses an application for permission to adduce expert evidence. What made it impossible was nothing in the order of District Judge Phillips, but Sandman's failure to adduce any of the evidence that it would need to support its case on the counterfactuals, including the expert evidence that it had said in subparagraph 5 of paragraph 20 that it would adduce. But leaving that point to one side, the other side's argument here seems to be that in circumstances where the judge had decided that the respondent was entitled to judgment for damages and the basis upon which those damages were to be assessed, they say it would have been contrary to the interests of justice for the judge to decline to vary the order of District Judge Phillips, because that would have resulted in Sandman losing the hotel site claim. Well, there's nothing contrary to the interests of justice about a claimant falling at the first hurdle or the final hurdle, or whichever hurdle, if it has failed to adduce the evidence at trial that it needs to surmount it. So that's obviously not a sustainable ground. It can't be a proper way in which to exercise the discretion in CPR 29.9. That discretion cannot sensibly exercised to ensure that one side wins or at least doesn't lose. That would be a wholly unprincipled, unfair and unjust basis on which to exercise the discretion. It would actually be contrary to the interests of justice, which amount at their heart to the importance of playing by the rules. And those rules include the rule that if you turn up at trial without the evidence you need to win, then you lose. You don't get a second chance. And we come back to my Lord's point that the trial is not a dress rehearsal. It is the first and last night of the show. This was the first and last night of the show in respect to the issues in paragraph 11.1 of the order of District Judge Phillips, and the absence of any evidence meant that the counterfactual issue should have been decided against Sandman. So, my Lords, that's Appeal 2. And can I finally mention briefly the two cost points? In Appeal 1, ground 6, and I don't expect my Lords to turn it up, but for the transcript, it's core bundle, page 325, where we say the judge erred in law by ordering the appellants to pay 71% of the respondent's costs of the applications. He should have ordered the appellants to pay 49.5% of the respondent's costs on the basis of the respondent's own cost schedules, apportioning its costs to the applications. That arises if Appeal 1 is otherwise dismissed, and I refer, my Lords, to what we say in our skeleton argument in the core bundle at pages 350 to 351. And then ground 2 in Appeal 2, again for the transcript, it's core bundle, page 423, where we say the judge's order on the 23rd of January 2025 refusing the 2nd to 4th and 6th defendants' applications for the costs thrown away was wrong. That only arises if Appeal 2 is otherwise dismissed. And again, I refer your lordships to what we say in writing. It's in the core bundle at page 442. And so I rely on what we've said in writing on those. Unless your lordships have any questions for me, those are my submissions.
Thank you very much, Mr. Robbins. Yes, Mr. Mallon.
If I could just ask this first, I would intend, if it's convenient to your lordships, to deal with Appeal 2 first. There are a couple of reasons for that. One is actually it will fit relatively conveniently into the time we have remaining, I hope. The other is, of course, we've just heard those arguments. And also there were some things hanging overnight in terms of what was disclosed at what times. And I would actually prefer, but again, of course, I'm subject
Sure,
to your lordships.
you go ahead.
Thank you. So the first,
Just before you begin launching into Appeal 2, do you accept that if Appeal 1 succeeds, then Appeal 2 must succeed as well? Because the judge would have been wrong in debarring the defendants from striking out the defence and debarring them from participation.
appeal on Appeal 1 would be precisely that.
Right.
And I understand that a retrial is being sought. I think that's in the appeal notice, if I'm not mistaken, but that would seem to be the logical consequence of success in any event. In those circumstances, unless somebody behind me tells me I'm completely wrong, it would seem that the judge's decision at the very least must fall away. It needn't even be wrong. It would have been
So you, like Mr. Robbins, are going to approach Appeal 2 on the basis that the judge was entitled to strike out the defences and debar the defendants from participation.
My lord, yes. And if I could then, there's just a couple of preliminary points on this. One, my learned friend took a sort of respondent's notice point, although he did in fact address the substance of the matter in any event. I wonder if I could just invite your lordships to turn up my skeleton argument, our skeleton argument on the second appeal at core bundle page 443. And you'll see there a summary of the bases on which we say the appeal should be dismissed. And I'll come back to these in more detail, obviously, but just to see what we are saying in summary. The appeal is academic, since even if the appellants were to succeed on ground 1, that wouldn't change the result, because there's no challenge to damages to be assessed. And that ties in very closely with the whole question that was touched on, but in my submission analysed incorrectly by my learned friend, the whole question of what's been established so far. And there is an important distinction in my submission between causation and quantification, and the mere use of the words but for, I don't take you there, but I'll come back to that. I don't want to develop it for the moment. But then we have, ground 1 is a review, we say, of a case management decision by a trial judge with power to decide how the trial was to be conducted under 29.9. We say further, the judge had the power as trial judge to order the counterfactual issue be adjourned to the second hearing. That's just the issue, not a broad-based adjournment. And the Court of Appeal should not interfere with such a case management decision. So in essence, we say the judge took the view that he had a discretion to make the order that he made. We support that decision, and we don't fit, there's no need to qualify it. What label you give to that exercise of discretion, be it inherent power of the court, be it 29.9, be it the power to adjourn, or any other power, we submit does not go to the substance of this appeal. The question is, was the judge entitled to exercise his discretion in the manner that he did? Even when one looks at the commentary on 29.9, for example, it talks about recognising the power of the court to, in effect, manage its own procedures. And so we say there's nothing in the attempt to limit what we can talk about here. We go on, as your lordships will see, in the subsequent paragraphs to deal with adjournment and also 3.17. We say that's not expressly the power that the judge was exercising, or those aren't the powers. But if, in the alternative, they were, then the judge, exercised those powers correctly. So we say, ultimately, this is just a question of discretion. Did the judge have the power to do what he did? And if he did have that power, did he exercise that power correctly? And any fetters on our ability, in my submission, to make submissions to that effect would be artificial in the extreme, not least because we've set out our stall very clearly here, and what we are doing, in essence, is saying the judge was right. The other preliminary point, excuse me, my lords, is this. If we go back to this question of expert evidence, and what was ordered and what wasn't ordered, again, I have to express a certain amount of caution because I wasn't there. But if your lordships turn up again the order that was made, and that's in the supplemental bundle, tab 2 at page 8. We've already looked at 11.1, and in passing at 11.2, but if we look momentarily more closely at that, if the second claimant succeeds on those issues at the first hearing, the court will direct a second hearing to assess the quantum of the second claimant's damages and give directions for any further disclosure. Disclosure evidence, including expert evidence, brackets, if and as required. Now, my understanding, my lord, is from taking instructions on this, it doesn't appear in the order, but that expert evidence was in issue at that hearing, and that the judge ruled in effect that that should form part of the that second hearing. Now, where that goes is a different matter, but just so we see where we are in terms of fact, those are my instructions.
I mean, that suggests, and to be honest, I can see why rationally one might suppose this, that determining the counterfactual didn't really turn on expert evidence.
Which, as I'll come to submit to your lordship, it may reflect the view of the district judge to that effect. I agree with that. It certainly isn't and cannot be right in my submission, and I'll come to that.
Well, you'll obviously come to it, but on the face of it, if the question is, would things have turned out differently with a different owner of the site? You have to ask how these people would have acted differently.
But with the greatest respect, my lord, that's not the right question in my submission. And we'll see it in detail, but I will certainly answer that point now. What we have here is a very clear case found by the judge of in effect a conspiracy to injure. There were other causes of action, but in effect a conspiracy to injure, whereby the contracting party of the claimant was deprived of the value of the right to develop the hotel site. The contract of the claimant, second claimant, I'll call the claimant if that's, I hope that's clear, the contract of the claimant was only with the second defendant. So the moment these defendants so organise their affairs as to take the right that sits, that's the important thing in my submission. You take the right to develop the hotel out of the second defendant, and you have caused loss at that very moment to the claimant, because the claimant has a contractual right in respect of those rights, and those rights have been removed. It's, fairly standard conspiracy to injure type of territory, but in those circumstances, the question is this: what's the value of the removed right?
Are you saying this is a loss of a chance type case?
It could be valued that way, absolutely. But what it is in the first instance, my lord, and probably most appropriately valued that way, if I may say, but I do want to come back to that. But the critical first question, before you start asking yourself how do you value it, loss of a chance or otherwise, is to recognise that what has happened is that a right having value has been removed from the reach of the claimant. And I don't mean removed in the reach in the sense of a recoverability question. I mean the rights of the claimant were to the rights of the second defendant, if you see what I mean. So the moment you diminish those rights, you diminish the rights of the claimant.
In which case, you definitely needed expert evidence for what was an issue.
Here we get to it, my lord. Yes, absolutely. So let's ask ourselves the question. Imagine none of this sort of rather messy stuff had happened. We've just got a normal claim, and this, with the greatest of respect, on its face is a pretty normal situation. What would we be saying? What has the claimant lost? My learned friend says, well, they haven't developed the hotel, so they've lost nothing. Fantastic conclusion. That for a defendant in these circumstances, that simply can't be right, because what they've lost is the right. Whether that right has yet been taken to fruition is a completely different case. That's what the law of damages is all about. What we need to do is quantify the loss of that right. How do we quantify the loss of that right? Well, that I will come to in a bit more detail, if you don't mind, in due course. But it's clear in my submission that quantification of that right depends, I would submit this, I go this far. It depends almost exclusively on expert evidence. Because if the event has not happened, as it has not, and I'll come back to that, the fact that it hasn't happened in just a moment. But if it hasn't happened, and that's a very common situation where a person has been defrauded out of his rights, but the thing that crystallises the value of his right hasn't occurred, what does the court do? The court assesses that value. Loss of a chance may well come in, as your lordship suggests, and very often does. But the court doesn't hesitate. It doesn't sit there and go, well, I see that you've got this potentially valuable right, but you haven't done it, so it's worth nothing. That was my learned friend's analysis, and that analysis simply doesn't stack up. It cannot be right.
But do you have to show by evidence that it's worth something?
Well, I'll come to that. I think you have to show that something, I think the terminology was used, the more than theoretical value, in order to establish loss for the purposes of establishing the tort.
I mean, if I agree that you should have 50% of my profit in redeveloping Buckingham Palace, you'd probably say, well, that's worthless because it's never going to happen.
That's possible, yes. But that hasn't happened here. We've got a judge who has heard all the evidence and found as a fact that there's been loss and damage. We'll come to that. And with the greatest of respect, there obviously has been. You could treat it as a matter of common sense. There is a right to develop what is potentially a valuable hotel. It hasn't yet been developed. Does that mean that right doesn't have some value, that somebody won't pay something for it? Well, the judge has found, at least in effect, that it does. And I don't understand there to be any appeal against that finding as such. And as I would submit that as a matter of common sense, that it has value. The question is, how much is that value? And there's an interesting point here, and it's in a sense, on the basis of a proper analysis, it's a by-the-by point, but I'll make it anyway. My learned friend says, and we can see that there's no profit in there because it hadn't before been sold and developed, and it still hasn't. Well, how remarkable is that? A hotel rights sitting in the hands of proven fraudsters, and if you went and sold it now in some way for £5 million, just to pick a number, that would immediately crystallise the loss, my learned friend wouldn't be able to stand up here and say, incorrectly even then, there's no loss. So of course a fraudster's not going to do that. But
at the risk of taking you inconveniently out of your course.
Not at all.
I mean, you were supposed to plead, and you did, counterfactual scenarios. And as the district judge's orders stood, those were going to be aired in the first trial.
They were going to be aired in some sense at the first trial, yes.
Now, as you've explained it, it's not a matter of working out whether these defendants would have done any of these things. It's a matter of working out what value an expert would think the possibility of doing these things would have had.
Yes.
So you had no evidence on that at all?
Because there was no expert evidence at the first trial. So no, we did not. I accept that.
So you went into this hearing in circumstances where the counterfactuals were to be aired without, on your case, any evidence at all that could support a finding on them.
We didn't have any expert evidence, and we didn't lead any factual evidence. The critical point in my submission, my lord, is this, that the district judge having not provided for expert evidence and assuming that that went to the second stage, the consequence of that was that the quantification exercise, and we say it is a quantification exercise based on those counterfactuals, simply could not be carried out. And the judge, sitting then in a much better position than the district judge had been, was able to provide for the proper resolution of the issues.
Well, the district judge presumably proceeded on the basis that counterfactuals would indeed involve working out what would have happened. Now it turns out you weren't approaching matters on that basis. You said it really doesn't matter what would have happened. It's a matter of getting a valuer to work out the value attaching to the different possibilities. So contrary to what the district judge had assumed, you wanted to approach this as an expert evidence exercise, in which case surely it was incumbent on you to say to a court, we want the expert evidence.
Well, as I understand it, that did happen, my lord, but...
Well, you say it happened at the hearing before the district judge, before you'd even pleaded your counterfactuals. But, I mean, how could you go into this hearing without any evidence at all to prove the loss that, on your case, had to be proved by expert evidence?
Well, as I say, we didn't have permission to adduce expert evidence. The district judge, as I had understood it, had already refused that and directed...
Where is the refusal? Where is the request for expert evidence? We haven't seen that.
As I understand it, my lord, and again, I wasn't there, so as often happens, I suppose, in these relatively informal CMCs, the district judge, during the course of the hearing, declined to order expert evidence in respect of this first trial, and instead directed that it be heard in the second trial. Let me just check I'm getting that right.
Was it covered in the evidence at all by the witnesses who had filed some evidence? The question of the need for expert evidence. Was it raised in the
factual evidence for the trial? No.
And there was to be a PTR 4 weeks before the trial window started.
There was, and
so
of course,
if you had thought, oh golly, we need to have some expert evidence to prove the value of this right, you could have raised that at the PTR.
Of course, my lord, the PTR got, if I can put it this way, bounced by the various applications and so on that were being made, so that never happened.
I mean, in reality, you'd have needed to ask for the expert evidence earlier, so that both, well, pre the debarring order, both sides could prepare expert evidence. So it's incumbent on you, wasn't it, if this was not the way you wanted to present your case, to ask for expert evidence, supposing the district judge to have refused it, to appeal that, but I have to say it's not obvious you refused it at all. So you just went into this trial without any evidence to support your way, as you explain it now, of proving anything.
Well, what I want to do, if I may, and I entirely take the point, and I do want to address it, is just build the thing up so we're clear where we stand, and then talk about the power of the judge against that background, rather than, and don't misunderstand me, my lord, of course I understand the desire to raise these questions, but if I could just take the opportunity, just to set the scene, and so that I'm answering those questions squarely within the context of the way we put the case. So, in order to understand the procedural position, what was required in terms of evidence wasn't, in my submission, it is important to understand how the pleaded case actually worked. So if we turn to the core bundle at 179, and that's behind tab 12. We see there the re-amended particulars of claim. We re-amended, I think. And if we go forward in that document to paragraph 14, which is at page 183, you'll see the definition of the deal here, about halfway down paragraph 14. So it's the second claimant's agreement and the deal, paragraph 14 is under that heading. And you'll see the definition of the deal. Follows the second claimant's agreement incorporated and or was amended, supplemented, extended, etc. By the terms agreed by the second claimant and both defendants set out in the document headed the square, and that's defined as the deal. And if we go forward to 14 little, I think it's a little f, the numbering is a little curious here, but at 185.
Sorry, where are we going?
Go forward to, please, to page 185.
185, yeah.
You'll see a little f above paragraph 15. And that reads as follows: in the circumstances, the terms of the deal are contractually binding terms of the second claimant's agreement as a result of the party's variation of the original requirement in clause 2.3. So getting to that stage, what we have is a binding profit share agreement. And then we move to paragraph 20A. And the terms of the agreement are being set out. Paragraph 28 is at page 186. At the bottom of the page, apply clause 10 of the deal. Once loan is paid back, after 9-12 months, subject to an extension being granted, the second claimant has a profit share of 50-50% on flipping and selling, or just going forward, forward finance, build out of the scheme, i.e. obtaining planning permission for the property, constructing a hotel and relevant residential units, etc. And as you'll see, just at the end of that paragraph on page 187, the obvious point, thus realising profits for the second defendant. Second defendant being critical because that's the claimant's contracting party. And then if we go down to 20B, there's what is in effect a non-circumvention clause pleaded, an implied term, which the judge found to be correct, of the agreement and the deal, that second defendant wouldn't seek to structure any on sale of the property such that the second defendant's profits were artificially eliminated and or reduced so as to prejudice the second claimant's ability to realise its 50% profit share and or artificially to create and or inflate profits. So that's the scope of the implied term. It's seeking to avoid a situation in which the affairs of the defendants are so organised as to deprive value in the hands of the second defendant and thereby the claimant. And if we then go to 20C, we see the allegation of breach of that term and or the implied terms, sorry, the terms set out at 20A and or the term at 20B that we just looked at. And this is the core of the allegation. The second defendant has participated with others in a scheme whereby the second defendant has disposed of its interest in the property without receiving any economic benefit for its role in the transaction, and companies in the fourth to sixth defendants controlled by the same individuals who control the second defendant have been inserted into the scheme structure such that they will receive ongoing profits from the development of the property. Just pause there for a moment. The property is defined to include the hotel site and the residential premises, residential development. There is to be a quantum trial. The judge has obviously found for the claimants in respect of that, as he has in relation to the hotel site. There is to be a quantum trial in relation to the sixth defendant. So this isn't a situation where the trial ends depending on this judgment. It goes forward in relation to quantification of the claim as regards the residential premises. And the purpose of the structure that has just been pleaded is then set out clearly. The purpose of the structure: artificially eliminate and or reduce the profits realised by the second defendant in order to prejudice the second claimant. It's in effect mirroring the terms of the non-circumvention clause. Then we see the specifics over the page, which we may not need to trouble with now. So that's 20D, sets out the individual component elements of this scheme, the effect of which in summary was to transfer the benefit of the hotel site to the fourth defendant and transfer material benefit of the residential development to the sixth defendant, who was appointed as a development agent, earning 66,000 a month, and as I understand it, other monies, but that would be a question for the trial, and obviously no corresponding benefit to D2. This all culminates in what I think now is 20 capital D. It is small f at page 190, in red at the bottom of the page. The practical effect of the above was, again, it's similar language, to effectively strip the value out of D2. Now, pausing there, we'll need to go on from that point in a moment.
Sorry, just to look at
Yes.
paragraph F for the moment.
Yes, Mum.
The profits realised by the second defendant. Well, there aren't any, so it must be the profits capable of being realised or realisable or some such word, and realised by the second defendant from the transaction. Is that the same as the deal, or is that something different?
Let me just take a moment. No, that's not the deal. That's the underlying commercial transaction. So the second defendant should have had the benefit of the hotel site, which implicit in that are profits, obviously, but doesn't. That's what's being said there.
So, well, the practical effect and intention of the above transactions, plural, so that's the various things that have just been pleaded.
Those are the movements between
Yeah.
the defendants, yes.
The profits realised by the second defendant from the transaction. Is that the same transaction?
No, that's it can't be, Malone. I didn't plead this, but it can't be.
So what is it?
It's the underlying transactions having
Between whom and whom?
It's the transactions in respect of the hotel. We know that those transactions have moved on, if you like, so that the underlying commercial.
But there weren't. You pleaded earlier that the hotel was transferred without any economic benefit. So what profits are we talking about?
We're talking about the profits that should have been sitting in second defendant's capability. The value of the hotel rights should have been sitting with the second defendant.
Well,
They've been
all
given
right.
away for no value.
So that's realisable. It's not realised. They're future.
Profits are realisable. Value is there.
Well, the pleading talks about profits,
Yes, ma'am.
realised, past, and they haven't been. So we
No,
actually should be talking about profits capable of being realised in the future.
And giving value to the entity that is the recipient of those profits now. And I wonder, in substantive terms, my lord, when we're looking at what is effectively a fraud on the second claimant, whether talking about profit or value in this pleading changes that. I understand what your lordship's saying. It may be that had been better described as value, but in my submission, it's absolutely clear what this claim is about. It's about the removal of valuable rights from the second defendant and thereby from the claimant. So, against that background, but not finishing with the pleading now, I wonder if I could just ask your lordships to go forward, or go back, I should say, to the judgment. Is that behind? It is, so it's behind tab 8, same bundle, or bundle that is, at page 64. sorry, that is wrong. Bear with me a second.
That's when. It's like the call button. Divider of intimation.
Yes, that's the. Yes, my learning friend insists that I am in the right place, but I'm just identifying where the judgment is. The scheme of the judgment is this. First, the judge finds that the facts of the scheme are made out. And then he finds that loss is established under the various causes of action. So if we look, for example, at paragraph 230.
230.
230, my lord, yes. He says this under the heading, has Sandman proved that it has suffered damage as a result of 2020 breaching the implied term? I am satisfied that Sandman has proved that it suffered loss as a result of 2020's breach of the implied term. I have found A, Sandman is, in accordance with the terms of the deal sheet, entitled to 50% of the profit made by 2020. B, 2020, in breach of the implied term, entered into the scheme, as a result of which it has received and will receive no commercial benefit from its interest as purchaser of the two leases. That's essentially what was going on in the hotel site transaction. In fact, it's received less than it paid for, see, whereas 217 and 230 above. And C, Sandman has lost 50% of the profit that 2020 would have made as purchaser of the two leases had it not entered into the scheme. The quantification of Sandman's loss is a matter to be determined at the second hearing. So in my submission, the judge is perfectly correct about that. And what he's done there, he's not talking about quantification at all. What he's, at that stage, he is saying that loss has been caused as a matter of liability. It's been caused because the claimant has been deprived of the valuable or the access to the valuable rights which it had contracted to have. And it's worth just pausing on that just by reference back to one of the authorities to which my learned friend referred. He was very keen to say, to talk about all counterfactuals as though they were the same thing. So counterfactual, he pointed to various authorities and said, yes, that's something that has to be proved as part of liability. And his prime example, I think, was a negligent advice case. And it's, in my submission, perfectly obvious that if you're going to say, I, the claimant, maintain that I received negligent advice, you're going to have to say you relied on that advice in order to establish a liability. Because you wouldn't be, there'd be no loss caused if you received advice and did nothing. The obvious way to do that is to say that but for the advice, I would have done something different. That's the completely standard way of addressing a claim for negligent advice, for example, the tort of negligent advice.
Well, actually, I think that in Sykes, the complaint was that the plaintiff hadn't been advised. So he wasn't relying on something the solicitors said. They had failed to advise him on the consequences of entering into the lease on the particular terms that it was on which it was granted.
So be it, my lord. I'm talking in rather general terms, but omission would come to the same thing. You have to prove some form of reliance, and there your counterfactual, the counterfactual analysis is necessary to establish the component elements of the tort. Here, the component elements of both the claiming contract and the tort are fully made out at the moment in which the judge accepts and the judge finds that value has been removed from D2 and thereby the claimant has been denied the rights that the deal gives him. So in my submission, those tort cases that are based on negligent advice and other similar circumstances have no bearing on a case like this. It's perfectly possible to establish, and indeed I would submit quite normal, to establish that a loss has been suffered by a given mechanism, removal of value in this case, and in order to determine how much that, or what's the quantum of that loss, you have to enter into some form of investigation of what would or could have happened but for that. So
It's fair, is it, to say, supposing that you read this as the judge finding that there has been loss, he never explains at all how he could make that finding. Is there anything in this judgment that explains how the judge could find that there was loss?
it's inherent in my submission, my lord, in the fact that the claimant had a right to participate in profits.
Well, a potential profit. So you can't say that a right has any value without knowing more. You may have lost a right, it may have been a worthless right. Does the judge anywhere in this judgment explain how he concluded, if he did, that the right you lost had any value?
I don't believe there's any express finding to that effect, but I will say this, my lord, that it's a bit of a curious situation if you have a commercial transaction between parties seeking to make a profit, and a number of those parties get together to deprive, and this has been found by the judge, to deprive one of their, let's say, external partners, because that's in effect what he is with the 50-50 profit share. Those parties set about to remove the right of that party, in this case the claimant. It wouldn't be, in my submission, a hard inference to say that there is something of value of which the claimant is being deprived. It would very often, in my submission, be the case. Let us say, my learned friend was very keen to emphasise that this wasn't a simple, straight down the line liability quantum trial. But it's very often the case, obviously, that it is, and there'll be a finding that the party has suffered loss, which must now go off to be quantified. And in my submission, it's inherent in very often, at least, in the circumstances of the case, that there is something at least potentially capable of having value. You might even say that arose on occasions in the context of 994 petitions, when you've got no idea of the value of a company, often at stage one, but stage two you have, and it might turn out that although your shareholding has inherent rights, those shares turn out to be worth nothing, and very often experts on the other side will say that that is exactly the position. But you're entitled to assume that
if the issue is whether the affairs of a company have been unfairly conducted, does that depend on whether the shares have any value or not? I mean, are you entitled to conduct the affairs of a worthless company unfairly to the petitioner? The distinction that Mr. Robbins is making is that loss is an element of the gist of the tort,
I fully understand that,
where it's not in a 994 petition.
So that I accept that. That may not have been the best example, but what I was really trying to press for there was the fact that you'll often have a two-stage trial.
Of course, yes.
With no knowledge.
Absolutely. The question is, what have you got to prove at the first stage?
Yes, but in my submission, the language of what you have to prove is essentially that there is a substantial loss, in the sense that there's not something that is simply theoretical or negligible. That can't be the case here.
But the mere fact that someone's lost a right doesn't mean they've lost anything at all of value. I mean, take a right in a company that's hopelessly insolvent. Well, if the shareholder loses a right in a company that's hopelessly insolvent, they've lost nothing.
But in my submission, my lord, you almost might then need to reverse the burden of proof, because if someone's saying, I have been deprived of what on its face is a substantial right, namely the right to develop this hotel, and somebody wants to say, well, but that right's worth nothing. They're not saying that here, interestingly. What they're saying is that it hasn't happened, and therefore there's no value. And they say something.
They weren't allowed to say anything. Isn't that the problem?
No, I don't think it is the problem at all. They did make, in fact, Fire Council, they did make certain representations at trial, particularly on this point, I think, actually, if I'm not mistaken.
That's right. Max, have a look at the bit that's highlighted on that page.
Ah.
It's from the court number.
I'm just being pointed to something. Would you, Lordship, give me just a second? Yes, that's very helpful. It makes the point I've been making, but it's made by the judge and therefore has greater value than being made by me. And that's at core bundle page 137.
So it's just before the value.
And it's, so in little Roman 3, I infer that the fourth and sixth defendants were expected to make a material profit out of the underlease of the hotel site transferred to the fourth defendant and the development agreement entered into by the sixth defendant. Otherwise, they wouldn't have entered into those agreements. And there's no appeal against that finding. And it was a finding in my submission which the learned judge was perfectly entitled, indeed, I would say on the facts, obliged to make. And we're not, of course, in any of this getting away from the need to prove in due course the quantum of the value of that right. And that could be, in any normal circumstance, we'll come to just how this has played out in a moment. As I said before, that in any typical circumstance, that would either be by reference to what's actually happened in the event, in this case, so far, nothing, but for perfectly understandable reasons, or to the value of those rights at the time of the trial. That would be the normal way in my submission assessing, or there might even be an argument whether the right time of valuation of those rights would be the time of breach. But either way, valuable economic assets are not, in my submission, valued by reference to what actually happened or didn't happen. They are valued by reference to the inherent value that derives from their potential to make profits. And that brings us back to, of course, to the fact that that's a matter of expert evidence in large part, no doubt. Because what we're looking at is either actual, if by the time of the trial the hotel had been sold, or hypothetical scenarios in the event that it hadn't. And any valuer would have to look at various ways that might occur. And so if we just look for a moment at para 276 of the judgment.
So I'm just trying to understand the way you're putting your case.
Sure.
I can understand a case which says, well, I've got this right over a piece of land. I don't know what's going to happen to it. I want to know what it's worth. And so the valuer will look at all the possible things that could happen to it, and he will say, well, there's a X% chance of this and a Y% chance of that, and this might happen and that might happen, and therefore I put a value on this right, and I come up with so many pounds. But if the right is a right to participate in profits that somebody else makes, you've got to decide somehow or another what that somebody else would have done, given that, as far as I can see on what we've been shown so far, there is no obligation on that somebody else to do anything. Is there?
Save for their own commercial self-interest.
Right.
Isn't that, my lord, though, with respect to the circumstance, into any, let's just take a simple joint venture arrangement.
No, because there you may have fiduciary obligations to each other. You may have a defined goal that you're trying to achieve. That's not this case where, as far as I can see, the counterparty to your client didn't promise to do anything in order to bring about the realisation of the profits which they might have.
Well, I mean, I may need to get a reference back to the actual terms of the deal, but my lord, if I may say, that does rather fly in the face of commercial reality. If you've got two commercial counterparts, and they're each entitled to 50% of profit from the exploitation of an asset, then I agree with you that there is, of course, some form of hypothetical analysis of what would occur. And I've been very frank about that. I accept that that's how it would be. I'm not so sure personally that that would involve an expert assessing the willingness of a person, one of the counterparties, to go ahead with the commercial deal, but it would obviously involve situations or considerations such as what was the marketplace like for the development of the hotels? Were there available counterparties to take on the development, and those kinds of considerations? What was the real estate market like? Arguably, there are a number of things. But we say that's as far as it goes there, leaving aside the, if you like, the issue around the directions that were given, that's an extremely normal circumstance in my submission. Evaluating those right in those circumstances is very common indeed. Just bear with me 1 second, Philip.
Agreements at page 24
Yeah, I'm reminded very helpfully that the deal is at
it's core bundle 241.
core 241. It's pleaded there that it's 241, or it's actually the terms of it there are annexed to the pleading and the there's a right to step in effectively. If the loan isn't, this is paragraph 6, the bottom of page 241, if loan isn't paid back, no extension is granted, the lender will take over the deal if the deal is available at his discretion. Again, if the
What's the
extent,
deal referred to there?
that's the deal that we're talking about, my lord, the development of the property. That's the square, 111 Broad Street, as you see from the title at the top of the page.
That suggests you'd have wanted evidence as to what you would have done.
Yes, but saying what you would have done is straightforward.
But did you say it? I mean, was there evidence before the judge explaining that had there not been the transfer of the hotel site, you would have been entitled to exercise clause 6, and you would have done so, and then you would have done such and such and such thing?
We're not saying, my lord, that is the factual position, because had matters gone as they were agreed, it was agreed they should have gone, the second defendant would have held on to the relevant rights, and we say been developing in them the way that you would expect. So there would have been no need.
So is clause 6 relevant?
Well, it shows a power of step in under certain circumstances. In my submission, the underlying position remains that you have something of value and it has to be valued. The judge has found that it's something of value by finding what in my submission is a correct inference from the facts that these rights were valuable. After that, the question exactly how you value them is one that has to be determined, at least in part, by expert evidence.
I'm sorry, I'm afraid I'm still a bit lost, Mr. Manning. It's definitely my fault. The deal that you have pleaded, as I understand it, is that referred to in paragraph 10 of this document on page 242. That is to say, the profit share of 50-50 on flipping the site with planning or forward finance build-out scheme.
Yes, my lord.
What I have not yet understood is what deal is being referred to in paragraph 6, which you referred us to, where it says the lender will take over the deal. And you say the deal is, look at the heading, yes, all right, there is a word deal, and it somehow relates to the square of Broad Street in Birmingham. But what is the deal?
As I understand what the deal is intended to refer to there, my lord, is the development of the square.
Right.
which has two components, the hotel site and the residential site.
And do I get this out of this document?
I would say, my lord, that i.e. the whole case has been about the development of the square in two
Well,
ways
I understand
is
that, but
common ground
when
and
it,
in the
when it
judgment.
says the deal, it sounds as though there is in place some agreement to do something with the square. And I don't know what that is.
Well, we
it matters.
pleaded it earlier on, my lord, that the
No,
deal
what you-
was
what
the
you pleaded is
arrangement entered
paragraph
into
10.
between the second claimant and the second defendant.
And that's paragraph 10.
Paragraph 14 of the particulars of claim.
Yeah. That's where I started in identifying what the deal was. It's the arrangement entered into pursuant to the short-term loan agreement, absolutely, as the Lord says, helpfully at paragraph 14.
Right, there's a loan. So what does it mean when the lender has the right to step in and take over the deal? Can't be the loan because he's lent it.
Yes, it's the combination of the loan and the profit share. So, in other words, the defendant, the claimant, I'm so sorry, steps in and takes over the whole operation because he's not got his loan paid back.
So what, he's entitled to take possession of the site, is that what you're saying?
The rights to the site. So there are two leases, as I understand it. Yeah. Yes.
I see.
So if we look then for a moment back at the judgment at 276, page 276. Just bear with me a second.
Do you mean paragraph 276?
I'm afraid I do, yes, sorry about that.
It's 156.
158, page 158. Thank you. Your Lordships will see here a summary of the submissions I made about the question of loss and damage and how it should be put. And the judge summarised those as follows: that Mr. Atkins mischaracterises Sandman's case. It's not a claim to trace an asset, it's a claim for damages. And that, of course, goes to the point that once you've established your right to the benefit of the asset in question, it doesn't matter at all whether it's been sold or the benefit of the asset realised. It's got a value, and that sounds in damages. And then I go through, the judge records my having gone through the various paragraphs of the pleading, and then E, again, for the hotel site, experts will need to opine on what the likely outcome would have been if there was no litigation and no injunction in place preventing the hotel site being disposed of, because that is an element of counterfactual consideration that would have to be taken into account, because obviously the ability to develop a hotel when there is pending litigation surrounding it, and there is also a freezing injunction against the third defendant.
Yes.
Against the third defendant. So in those circumstances, obviously that would be an element of any analysis of the value of the hotel. You'd have to say, well, obviously we're looking at the hotel in circumstances where there is no litigation, because that's the value of which you've been deprived. And then we go to the part where the judge considers whether, this is para 277, whether the issue is one of causation or quantification. And then the judge, in my opinion, completely accurately, makes the following conclusion at para 278, which is, in my judgment, determining which counterfactual scenario should be used to value Sandman's loss in respect to the hotel site is a quantification issue and not a causation issue. And he makes these various points. First, Mr. Atkins' point about but for, which is exactly the point my learned friend also made, saying that that wording is often used in the context of causation. Nonetheless, para 20E states that Sandman quantifies the loss and damage suffered on the following basis, and it might be worth actually just turning that up now if we go back to the pleaded case.
Yeah. Just before we go there, you might wish to point out that at paragraph 266, the judge holds that Sandman has suffered loss as a result of the conspiracy, and at 267, that Sandman has suffered loss as a result of the procuring of the breach.
Yes, thank you, my lord. I mean, there's no question. I took your lordship only, I think, to the contract one, but he finds it in relation to each of the
Right. Now you want us to go back to the plea
causes of action. Yes, please. Let's just. So behind tab 12, I think I need 20.
page 191.
We had just finished at page 190, yes, and your lordship helpfully says we go forward to page 191. And these words appear in the pleading. By reason of the said breaches, the second claimant has suffered loss and damage. So that, by reason of the said breaches, the second claimant has suffered loss and damage is obviously the pleading of causation arising out of the relevant breaches, be they of contract or tort. And then, after the lines that are being crossed out, we see these words. The second claimant quantifies the loss and damage it has suffered on the following bases. And then we see quantification. So, in my submission, the suggestion that this is, that the counterfactual exercise is one that is necessary to carry out in order to establish liability is simply wrong. It wasn't pleaded in that way, and the judge didn't determine the case in that way. What he determined was the causation had been made out. Your lordship, excuse me, sorry, helpfully pointed out two additional paragraphs where that happened, but he essentially found that across the causes of action that were pleaded, and that is entirely in accordance with the pleaded case. So, if we pause there, what we've got is a situation in which the judge has found that the various causes of action are made out, including causation as to damage, and so the only matter left to determine then is quantification. But what is being said is that he can't do that. He must go on to determine certain counterfactual issues on the balance of probabilities, as I understand it. So he must go on to do that at this trial, whereas those counterfactuals can only be part of a quantification issue. They're not part of the liability issue, and therefore the judge, it's being said to the judge, and we're going to look at the powers he has to deal with this in just a moment, but what is in essence being said to the judge is, here you are, by the procedure that has been laid down, you arrive at a situation where you've done your job in terms of determining liability, including causation. There is a direction, the force of which we'll see in just a moment, for the to deal with, I'm going to put it neutral in that way for a second, certain counterfactuals, and the judge, exercising what we say is a perfectly proper discretion, determined that the only proper way to determine quantification was at the quantification trial, and that therefore there would be no going forward to deal with these counterfactuals on a balance of probabilities or any other basis.
Can I just ask something else? About the counterfactuals, which I don't think I've really got my head around. We know, I think, that as a matter of fact, nobody has done anything with the hotel site.
As far as I understand it, that's right, my lord.
In the normal counterfactual situation, the claimant says, if the system of work had been safe, I would have worn a safety harness on the date when I had my accident. Or if I'd been properly advised, I would not have entered into the lease when I did. So these are all events which have happened in the past. And therefore, one can see why a counterfactual needs to be proved on a balance of probability.
As a matter of causation.
As a matter of causation. The profits that your client stands to realise are to be realised, if at all, in the future.
Correct.
And it's not part of your case, is it, that but for the breach of contract and the various torts, the hotel would have been developed or sold at a date prior to trial?
It's our case that the right to do that has been removed from us, and that right has to be valued. Now, if...
Well, this is where I'm getting a bit lost. The judge records quite expressly that you did not say that this was a loss of a chance case. You did not want your damages assessed on the basis of loss of a chance. Well, I don't at the moment see how it is possible to prove on a balance of probabilities what is to happen in the future.
Well, my lord, we say that's a matter for quantification. If it be right that we can't do it other than on a loss of a chance basis, then prior to any quantification trial, we would have the right to apply, to amend, and the judge would either agree with that or he wouldn't. And in fairness, my lord, that's, again, we should keep on saying this, but a reasonably common event that relatively late in the day someone thinks, well, actually the way I'm dealing with my my damages claim requires at least an element of loss of a chance. Sometimes it'll be a combination. But there's another thing there actually, my lord, and this actually goes back a little bit to the McGregor on damages passage, which is this, that loss of a chance, just like causation, comes in two different ways. So it comes in when a party needs to prove causation, but he can't prove causation, or is very unlikely to prove causation, because that party is talking about the actions of another person. So loss of a chance comes in those circumstances to assist in that. So what it says is, as long as there's a more than minimal chance that the other persons would have acted in this way, now you don't have to prove to the balance of probabilities that they would have done. The court can ascribe a probability to that. It might be 20%, it might be 40%. But that's classic loss of a chance territory. It affects substantive causation. Now, there is a separate, and very often the loss of a chance terminology is used relatively loosely in this sense because the two things overlap. But where you have already made out causation, and we have, loss of a chance isn't a formal legal doctrine. It's the approach that a valuer may choose to take. So, for example, if a valuer valuing a business or an asset on a discounted cash flow basis, that would be another way of doing it. He might say, well, the risk of this outcome is higher or lower, and therefore I'll ascribe a higher or lower discount rate. That's one way of doing it. Another would be he could apply chances of outcomes. That's not the legal doctrine of loss of a chance. And in my submission, that would not have to be pleaded. What ought to be pleaded is if you are, if you require to speak of what the what a third party would have done in order to demonstrate causation. So, for example, I don't know, poaching clients. If you need to establish you've suffered loss because someone's been poaching, or at least is giving themselves the opportunity to poach, you might have to prove what other persons would have done, the employees or the clients, whatever it might be. In those circumstances, the doctrine of loss of a chance, properly so called, comes in. It doesn't come in here. It's got nothing to do with that case because we have established causation of loss without reference to it. What a valuer might choose to do, and I emphasise might, is look at the value of this asset by reference to the possibility of various things happening. One way or another, he would have to consider those sorts of elements. How he did that would be a different thing. But so I retract what I said earlier about the need even to apply for permission. That would not be necessary. This would be a pure quantification exercise. In my submission, the normal way of dealing with that would be you first get an expert to opine on what the correct approach is. How would you value these things, this asset? And then move on to expert report. But the answer to your Lordship's question, I think, is this, that we do not need loss of a chance as a legal doctrine, as a component element of causation of loss. No, we don't need that. Does an assessment of the possibilities or probabilities of certain outcomes come into the valuation of the rights? Yes, but they are two different things.
Yeah.
May I just ask,
Please.
because it's not clear to me from the sequence of orders, whether when District Judge Phillips had ordered in paragraph 11.1 subreference 2 that the first trial would deal with the appropriate counterfactual scenario for the purposes of assessing quantum. So she had it in mind that the court at the first trial would look at the factual issues and decide on which basis quantum would then be determined at the second trial, which is contrary to the position you now advocate. Did your clients, will you take any steps in relation to that direction to seek to vary or have it discharged?
Certainly not as far as I'm aware. I think I can safely say no unless I'm contradicted. Again, I wasn't there, so but my understanding is no. No. So if we could then, against that just go back to our skeleton argument, which you should have in the core bundle at 443. And we make a preliminary point there, which is connected with the points I've made, but I'll just focus on it for a moment. We say the appeal should be dismissed because as a preliminary point, the appeal is academic, because what's been established is liability, including causation, and the order is for, and the consequence of the judgment is that damages are to be assessed for breach of contract and tort. And that's essentially where we are, so that the non-proving, even if it has to be put in that way, and I'm going to come in a second to why it doesn't have to be put in that way, but the non-proving on a balance of probabilities of those counterfactuals doesn't enter into it. You've simply not proved those things. But the fact is, you have judgment for damages to be assessed. And so that should just go towards go forward to the quantification hearing, and they should be assessed
Can I just
in a relevant manner,
pick that point up?
please.
Looking at the appellant's notice in Appeal 2, page 414, section 9.
414.
Yeah, what are you asking the appeal court to do? The box is ticked saying vary the order which I'm appealing and substitute the following order. 1, the claim with respect to the hotel site is dismissed. So how do you say that's not challenging judgment with damages to be assessed?
No, what I'm saying is that's obviously what they want. No, what I'm saying is that the consequence of a finding that those counterfactuals had not been made out would not be the dismissal of the claim.
Well, that depends on what view you take of whether the judge had to go on and deal with it or not.
No, but what I'm taking from it, we say he didn't, and that
Yeah.
there's this preliminary point,
Yeah.
which is that all the court could do as regards those counterfactuals will say they're not proven. But we say they're not relevant, that they don't encompass
I
and
understand.
encapsulate the quantification process anyway.
Yeah.
And it's actually quite interesting, and it's a related point. And in a sense sets the scene for the further submissions. If we go back to 11.1 at page 8, the order is this. At the first hearing, the court will try the claim by the first claimant against the first defendant on the following issues: whether the defendants are liable, and what the appropriate counterfactual scenario for the purpose of assessing quantum is. So, my lord, on the face of the order, it's not saying we are going to go forward and determine whether there was whether this, I don't even know how to phrase it actually because it's very difficult, whether on a balance of probabilities, these hypotheticals are made out or not made out. What's being said is we need to decide which is the relevant one. And your lordships may have noticed that what the judge did actually was to cut our case down to the our primary case on the hypotheticals. I know your lordships noticed that in the judgment. I can pick up the reference to that. I'll give you that reference in just a second. So at one level, one could resolve this conundrum, if it be a conundrum, and in my submission the court has more than ample power to deal with this situation, by a proper reading of that direction, which isn't to say a given factual scenario has to be proved, it's to determine which of those is appropriate before we go to the quantification. That, of course, would solve the very vice that at least Mr. Atkins at first instance said was the problem here, which is that there'd be just too many things the court had to deal with.
I'm not sure Mr. Robbins has developed this point, but certainly somewhere it's been said, well, the reason that the district judge took this approach is so that at stage 2, you could have an expert focusing just on one scenario. Do you think that would be right?
Well, I can't comment on what the judge was thinking, and because genuinely I find that quite difficult to follow. But that would not work in my submission as a matter of principle, because you're deciding on the balance of probabilities what would have happened, and then simply quantifying, and that's no way to. So, well, the financial implications of that would have been this, again, on a balance of probabilities.
And then, presumably on that basis, she says, well, you better amend to put forward your counterfactuals, and you do that subsequently.
Yes. So what I'm suggesting is that one way of reading this order, and my submission is it is not clear, is that all that was even intended, right or wrong, even intended at the time, was that you would select a counterfactual that would be the one that would go forward to the quantum trial. as opposed to seek to prove it.
And supposing that that were right, so that you're selecting the counterfactual, how is that to be done at the first trial?
Well, one would have anticipated, and this foreshadows slightly submissions I'll make, engagement from the defendants. It was expressly envisaged. There was no engagement, and then obviously events took over as they did. And at that point, the judge made the order that he made, which was cutting down our potential counterfactuals.
Where does he do that?
I've got the reference here, well, it's at paragraph 280.
Where in the order?
Core bundle.
Where in the order does he do that?
Oh, in the is it reflected in the? But I have to check the extent to which is reflected in the order. He's made it very clear in his judgment. I'll just be checking whether it's actually found its way into the order or not, my lord. But did it? Could I just show you where it is in the judgment while we're waiting for that? So it's at page, I'm told it's at page 161. Yes, it's at paragraph 280. And your lordships will see, it's worth looking at the whole paragraph actually at this point. In those circumstances, I declined to determine as part of the first hearing which counterfactual scenario should be used for valuing Sandman's loss. The choice of the correct counterfactual scenario is an issue, along with expert opinion, as to the value at which the hotel site would likely to have been disposed of in those various counterfactual scenarios that I will direct should be determined at the quantification hearing, with the benefit of expert opinion on at least these issues. I will, however, restrict the counterfactuals considered at the quantification hearing to those scenarios pleaded in paragraph 20E of the particulars as Sandman's primary case rather than its secondary case. I do so because A, for the residential site, Mr. Atkins accepts that Sandman's primary case is the appropriate basis for valuing Sandman's loss, and B, the defendant's defences have been struck out, and so Sandman is entitled to have its loss quantified according to its primary rather than its secondary case for the hotel site. And that, I'm told, is in the order. What's that?
Page 62, paragraph 5.
Page 62.
Cool.
Page 62 of the core bundle, paragraph 5. This is the order of the 24th of December.
Paragraph 5.
Paragraph 5 on 62, my lord.
Yeah.
The issue of which, if any of the counterfactual scenarios pleaded in paras 20E 1 to 5.
So there are still 5 potential scenarios.
Yes, ma'am. But the judge, as I say, cut them down, and and my suggestion is that an accurate reading of the order never called for a determination on any basis of those.
I thought you said a minute or two ago that the order required a counterfactual to be selected.
That's what I mean, yes, just to be selected, i.e. this is the correct approach.
Well, so
Rather
but the judge here has selected 5.
He has, that's true. Just bear with me a second.
Primary case.
And they're all alternatives.
Secondary case is one follows. They're all separate component parts, they're not alternatives.
So, my lord, no, and I accept that. What I'm trying to get to, though, is that the order, on a proper reading of it, may not in any event have been intended to do that which it's argued it was intended to do, namely provide for the on a balance of probabilities resolution of each of these counterfactuals. In those circumstances, all the points about where you didn't put in the evidence and therefore those claims must fail don't arise. We are in a again, a case management situation.
I mean, I can't claim to have looked at all these authorities. I can see there could be scope for argument as to whether, as you say, you simply value the right that you say you've lost, or whether, on the other hand, you don't do that. You look, applying, I suppose, the Bulfer principle, that you look to see what's actually happened, or whatever. You look to see what would have happened had the wrongs not been committed.
Or if I may, sorry to interrupt, but just to qualify that slightly, the first level of counterfactual there, which is pleaded and accepted by the judge, is the obvious reversal of what happened. So, but for the wrong, the rights would have been within D2. That's stage one, but then stage two is to value those, and that's not a counterfactual based on the scheme. That's a counterfactual based on what could have happened.
And all I'm just trying to get at is I can see that there might be scope for argument before a tribunal as to whether the appropriate approach to calculating any loss, to working out whether there is any loss and calculating it, is either A, your basis, well, look, we'll just value the right, or B, alternatively, we will look to see what would have happened. Now, you say, on my preferred basis, valuing the right, none of this really matters. Do you say that you would be able, in the alternative, at a future hearing, to say, well, if it does matter to work out what would have happened, we still can?
So the question is...
Suppose the judge in the end said, look, we don't accept that this valuation of the right business is the right way. We have to look at what actually would have happened but for the wrongs. And therefore, I have to work out, to make any finding of loss, I have to work out that there is some counterfactual that would have given you a profit.
Yes.
Do you say you could still argue that?
Can I argue it, as it were, procedurally? Am I somehow barred?
Yes, procedurally. Would it be open to you to run that alternative case?
I'll answer that question with a yes, and then, if I may, before explaining that yes, I'll just wind back a little bit, because with respect, I don't think the premise of that question is quite right, and it affects my answer. That's the only reason I raise it. It's the point that the defendants have made. They say our case is that, but for the scheme, we would have made the profit would have been sold and a lot of money. That's not the point. The point is, but for the scheme, we would have had the right. Stage one, completely separate. And it's important. I know I'm sounding a bit pedantic about it, but it is important. Stage one. Now, what's that right worth?
And that's why you say, we'll forget about the counterfactuals, we'll just look at the right. But suppose the judge in the end said, no, that's the wrong way of looking at it. We have to look at the counterfactuals. On your submissions, are you entitled to do that, or should you be entitled to do that in the alternative?
Yes, because we have established liability, and we're now in quantification terms. There are different ways of quantifying, and some of those, it could be argued, in my submission it would be unusual, but it could be argued that you can only establish the quantum by reference to what the relevant people would have done.
So,
Now,
just cutting to the chase,
yes.
on this basis the appeal is not academic, because there might be a circumstance in the future in which you wish to revisit the counterfactuals.
No, because those counterfactuals, what would have happened, etc., would never be determined on this balance of probabilities in this balance of probabilities kind of a way.
Supposing that in some future scenario a judge said, well, that's how it has to be approached. We have to ask ourselves whether you have proved on a balance of probabilities that such and such would have happened. Do you say you should be allowed to advance that case in the alternative to your other one?
I do say we should be allowed to, because for the reasons I'm going to come to now, in my submission, the judge had the power to deal with the case as he did at that time, if then, going farther down the line, the premise of the proper exercise of that power must be that a future court has the right to give such directions as it sees fit.
So the appeal is not academic, because there is a potential scenario in which you would want to revisit these counterfactuals.
No, my lord, I wouldn't want to. Your lordship floated the hypothesis that it might happen down the line that somebody did, but it
You're
would
not willing to
still render
announce that possibility.
it would still render in my submission this appeal academic, because we would be in a completely different situation, perfectly entitled, because the premise must be the court has exercised a proper discretion, so it can't be in any way impeached going forward, that the court will at this hypothetical future stage make the relevant direction. That wouldn't make this appeal any the less academic, would it?
Well, now, your timetable goes on to 4:30, but we normally rise at 4:15, and I think you're going now to go on to a different point about the judge's exercise of his discretion too.
I am, and I can probably deal with that fairly quickly in the morning if your lordship were minded to rise.
Yes, all right, 10:30 tomorrow.
Thank you very much.